Love is a beautiful thing, but here is something most people don't realize. In the eyes of the law, love by itself means nothing. No matter how real it feels, no matter how long you have waited for it, no matter how certain you are that this is your person. Because marriage, no matter how personal it feels, it is still a legal institution. And the law does not ask, are you in love? It asks, is this allowed? And that's where everything changes. Because you can meet someone who feels perfect in every way. Someone who understands you. Someone who feels like home. Someone you are ready to spend forever with. And still, the law can step in and say, not so fast. That's why this channel exists. My name is Achachi, and here we don't just tell legal stories. We break down the ideas behind the law, the principles, the hidden rules, the things that can completely change your life without you ever seeing them coming. Because the truth is, the most dangerous thing about the law is not breaking it. It's not understanding it. If you are new here, consider subscribing and becoming part of this growing community. Because here you don't just watch, you start to see things differently. And if you'd like to support the channel even more, check out our merchandise featuring unique African wear, art and accessories that celebrate culture while backing this mission of making the law understandable to everyone. Now, let's talk about a wedding that was already planned, paid for, and ready to happen. A young couple in Uganda had it all figured out. He was 29, a medical doctor, respected and accomplished. She was 30, an agricultural economist working with an international organization, a university graduate with a career that had already taken shape. They were educated, independent, and deeply in love. Their wedding was set for June 24th, 2006 at St. Francis Chapel in Makerere University. Everything was ready. Guests invited. Plans completed. A future awaiting. But on June 23rd, just one day before the ceremony, something unthinkable happened. A man walked into court and asked a judge to stop the wedding. The man claimed to be the bride's father, and his reason, he said the couple must never marry. Not because they were not in love, but because of who they were. You see, both of them belonged to the Baganda tribe, and more specifically, they were from the same clan, Ndiga, the sheep clan. And in their culture, that wasn't just frowned upon. It was forbidden. To him, this marriage was not just wrong. He called it abominable, immoral, unethical, illegal. Because in many African cultures, marrying within the same clan is almost unthinkable. It is not the kind of scandal that simply shocks people and fades away. It's believed to disrupt something much deeper. A violation so serious, it is said to make the ancestors restless, to turn in their graves and invite misfortune not just on the couple, but the entire community. But then, the story took a shocking turn. The bride spoke. She said, "This man is not my father." And that moment, it hit harder than the lawsuit itself. Because this man had been there from the very beginning. Before she could speak, before she could walk, before she fully opened her eyes to the world. He raised her. He educated her. He loved her as her own without questions. And now she was saying he wasn't her father. You can imagine the shock, the silence, the disbelief. Because in many African homes, there's always that unspoken confidence, a belief that you can just know your child. No science, no test, just a look. Maybe it's the nose, maybe it's the forehead, maybe the way they smile. and you are certain this is mine. So for him, this wasn't just a legal challenge, it was personal. But before that moment, something else was already becoming clear in the background of the case. There had been no formal introduction ceremony between the families. In Baganda tradition and in many African traditions, that step is not minor. It is the moment where the bride's and the groom's families meet, negotiate, and formally recognize the union before marriage proceedings begin. But in this case, it was noticeably absent. And the suspicion was clear. It was suggested that the couple had deliberately avoided it, not by accident, but strategically. Because they knew exactly what would happen if the families met. The objections would surface, the clan issues will be raised, and the father, firm in his cultural authority, would likely shut everything down before it even began. Some even believed the couple thought their Christian faith and a civil ceremony will be enough to separate them from those cultural expectations. But what they may have underestimated was this. Long before they ever identified as Christians, they were born into culture, into clans, into traditions that had shaped their families for generations. And those ties were not something that could simply be erased overnight. So instead, they moved forward quietly, hoping that a civil ceremony at the chapel will bypass the cultural gatekeeping entirely. But tradition in this case was not easily avoided. Because among the Baganda, much like many African communities, holding a formal introduction ceremony where both families meet before marriage is not optional. It is deeply rooted custom, and its absence only added fuel to the conflict now unfolding in court. Then the DNA results came. They settled one truth beyond doubt. The man who filed the case was her biological father. Everything changed. In that moment, the foundation of her argument collapsed. Because now it was confirmed. She was Ndiga clan, just like her fiancé. But the couple did not give up. They raised a more technical argument turning to state law, insisting that custom alone could not break their marriage under Uganda's written legal framework. They relied heavily on the Marriage Act, arguing that it governs civil marriages and only allows objections where there is legal impediment, lawful hindrance, or a just cause. Their position was simple. If Parliament had not explicitly prohibited clan-based marriage, then the court could not invent one through custom. They further pointed to the Penal Code, which lists prohibited degrees of consanguinity, relationships that make marriage criminal. They argued that clan membership was not included in those prohibited categories. They also cited the Customary Marriage Registration Act, noting that only void marriages expressly prohibited by custom under that framework. From their perspective, the written law was clear. No clause directly barred two consenting adults of the same clan from marrying under the Marriage Act. But the court, in its analysis, it went deeper into the structure of Ugandan law itself. The judge examined not just statutes, but the entire legal hierarchy. The Marriage Act, which recognizes marriages, but does not exist in isolation. The Judicature Act, which preserves customary law so long as it is not inconsistent with written law or repugnant to justice and morality. And the Constitution of Uganda, which protects both cultural rights and fundamental rights, which also allowing cultural practices only where they do not violate broader legal principles. The court also noted something crucial. The Marriage Act itself does not operate in a vacuum. It contains provisions allowing objections based on just cause or lawful impediment. And in the court's view, established clan custom, deeply rooted, widely observed, and socially binding, could also constitute such a lawful impediment. So, the legal question shifted again. Not whether the written law explicitly banned the marriage, but whether it allowed courts to recognize custom as a valid legal barrier? And in Ugandan's legal system, the answer was yes. Because customary law, where not repugnant to justice or inconsistent with statute, is not optional tradition, it is law. The court concluded that Baganda custom prohibited marriage within the same clan was long-standing, widely accepted, not shown to be unjust or immoral, and not overridden by any written statute. Therefore, it remained legally enforceable. And so, the final decision was delivered. The marriage was declared illegal, null, and void. The couple was permanently restrained from ever marrying each other. And just like that, a wedding planned down to the hour was erased by law, culture, and identity. And so, the question remains, when people try to bypass tradition in silence, does the law still hear it, or does culture always find a way back into the room? Because for this couple, it did.
This court is your court, this court is my court. From the trial court to the appellate court, from the open sessions to the chambers of justice, this court was made for you and me. As I was walking that corridor of justice, I saw above me the banners of fairness. I saw before me the scales of balance. This court was made for you and me. I've roamed and rambled, followed by my footsteps, to the halls of justice and the judges' chambers. And all around me a voice was sounding, this court was made for you and me. When the court is in session and I am